Oh, let's do this. Good afternoon, everybody. Good afternoon, everybody. Hi, my name's Neil Kalin. I'm joined as usual by Michael Simkin, and we have a special guest today, Joel Kadish. Am I
Kadish,
sure?
Kadish, how are you?
Kadish. Great. Thank you very much. And I realized when I was sharing my screen, I did not have the full screen on. So give me a minute, and I'm going to correct that. Um, So sorry about that. Hold
That's
on. I'll be
okay.
right back with you. I'm going to stop sharing and fix that and come on back.
Sounds good.
Okay. Hopefully that's a lot easier for everybody to see. Great.
Beautiful.
Good afternoon. Uh, this is the real property section monthly discussion of case law and other things of interest. And today, the other thing of interest is Joel Kadish. So we don't want to spend a lot of time going over that stuff. So instead, I'm going to get us into our agenda for today. Here we go. What's what's up with us? So just as a reminder, this is a free webinar and it is available for 1 hour of free self-study MCLE. You will be getting your MCLE certificate probably early next week, if not on Friday, but I'm guessing early next week is when it usually gets sent out. And we also have a gift card for one lucky What's Up With Us listener. That the gift card is good for 1 hour of MCLE on the real property section portion of the CLA online library. And I know I never say this right ever, but that's essentially what it is. And we will announce the winner at the end of today's program. Let's see, you can see we've got some cases, we've got a great interview. We always start off with, we don't always, but we've recently been starting off with some announcements. So, we want you, write an article for the Real Property Journal, write an article for the monthly e-newsletter. The monthly e-newsletter, simple. An article could be one page, about something interesting that happened in your legal career or a case that you were involved in and you just want to put everybody on notice, or maybe you read about an interesting case and you want to prepare a summary and you don't want to have, a 20-page, 90 citation article about it, but you think everybody should know, great, get your name. You see, we have to the most recent e-news. Hey, there's a regular to the e-news, and that's Stephanie Germani. And this last month, she wrote about short-term rentals and long-term liabilities. So that's a really great article. And then we have somebody that I think is new to e-news. So Ravi Patel, thank you for writing for the real property section in e-news. And you wrote about AB 2424 about extending foreclosure timelines. So if you haven't read those articles, find the June edition of the real property section e-news article. And I think they're available on the website, the CLA website under the RPLS section. A lot of good webinars coming up. I put in the first one there something that has already passed, but I thought, you know what, we've got Joel here, and Joel's going to talk a little about about the law in Canada. And there was just a recent webinar on, I guess, buying and selling property in British Columbia, Canada. So if you're interested, you can catch that in the library. Maybe use your 1 hour gift certificate if you're the lucky winner. Some great classes coming up. We've got 10 what we call practice area committees or subcommittees on the real property section. Look at them. We'd love to have some people join. I participate in the ADR subcommittee or practice area committee, and I know we'd love to have a couple of other people join us. So contact Jose Mendoza if you're interested. And hey, I just wanted to remind everybody, sorry you missed our retreat early in the year. If you missed our retreat, don't make that same mistake in 2027. We hope that
Well,
you
tell them
join.
where it is. It's Yosemite.
It's going to be back in Yosemite. It was in Yosemite earlier this year. It's going to be back in Yosemite in the spring. What a fabulous time to be in Yosemite is in the spring before there's throngs of visitors there. And the weather's just really nice, great for hiking, great just for sitting outside if that's what you want to do. Enjoy nice, fresh, clean air. All right, I think I'm good there. Getting ready to start into our first case. AVL Test Systems versus Hensel Phelps. Is this the one you wanted to start talking about, Michael?
I well, if you want me to, I can. I can always
Okay.
talk. I'm pretty good at this babbling, right?
Okay.
But this one, okay, look, I the essence you have it right here. But why don't you go through and then I'll tell you my comments, like the
Okay,
footnote.
great. So here we have a system where AVL was a manufacturer of equipment that was going to be used by the California Air Resources Board. Hensel was constructing a building to be used, and measurements were going to be taken. I can't say that I really understand the technology or what exactly was being studied, but what does the Air Resources Board want to make sure that California's air is clean, right? So there's this big equipment that's going into this building, and you can see from the opening paragraph that AVL was paid $73 million, but apparently felt that they were owed more money. And Hensel said, well, we're not going to pay you more money. And you did not have a contractor's license. You were required to have a contractor's license. Our contract said you need to get a contractor's license. You eventually did apply for a contractor's license, but it was more than a year after the construction work start. And then AVL said, well, wait a minute, we don't need a contractor's license. We're supplying a finished product and it's a removable product. It's not permanently affixed to the property. And any work that we did was really incidental. Any what might be considered real property work was incidental to supplying this equipment. Well, what happened that the trial court granted the builder's motion for summary judgment. The manufacturer appealed, and on appeal, the appellate court reversed, and it says it reversed both rulings and remanded because what the court said, well, you know what, this was a motion for summary judgment. There was factual issues. It was improper for the court to make a decision either way, either in favor of the manufacturer or in favor of the builder. When we look at the exception to the contractor state licensing law, and since we had a factual issue, it was inappropriate for the trial court to make a decision one way or another. And you could see some of the information on your screen about the relevant sections in the contractor's state licensing law. Michael, what do you have to say about this one? I know you love these summary judgment cases.
Well, one thing about summary judgment cases is courts look for a reason, appellate courts look for a reason to reverse them because the general policy is to have a trial on the merits, right? This one, I saw in the footnote that there is 4,430 pages of briefing and evidence, 381 exhibits and expert evidence. Okay, I haven't seen that many. I've seen, I'm sure, 1,000 pages before. Some lawyers think that helps them create a trouble issue of fact. I think it makes judges frustrated. I've seen plenty of judges say, I'm not reading this. I don't think it helps. It's not my style. I'm more brief to the point. But I thought that was interesting. Um, but as far as like the underlying issue here, remember the public policy is to have a licensed contractor. Okay, and the whole issue about quantum meruit, or it's like some technicality over here, they're trying to say it's not attached. You know, you have contractors, such as they install, say, an oven. It's like, and there are some rules about what they call home improvement goods, right?
Right.
And like, is the oven attached? A sprinkler system attached? This case talks about some of those things, but the policy is really to protect people and have licensed people, and people pay for their licenses and everything else. So I have no problem with the decision.
Yeah, to me, it was interesting. You mentioned the volumes of material that were discussing the factual issues. Both sides in the analysis section, I mentioned that AVL, the equipment manufacturer, brought in a former contractor state license board um, official, to opine. Well, guess what? The builder also brought in a former CLSB, senior official who opined the other way, right? So somebody's going to have to be believed here, right? And then somebody's going to have to
Yeah.
take a look at, whether it's if it's submitted to the judge or whether this goes, to a jury to make a factual determination. Somebody's going to have to look at some very complicated facts, right? I hope if it goes to a jury that they whittle down those 4,400 pages, Michael, because I can't imagine any 12 members, are going to be trying to figure all of that stuff out. They're gonna have to kind of summarize what their different facts are on both sides of this case.
But this is a good case for lawyers to keep because it does talk about all the facts about what you could install that's attached or not attached, fixture, stuff like that. It's pretty good for that.
Yeah, it's really good, and you hit the point, which is what's the purpose of the contractor state licensing law? To make sure that licensed contractors are used when there are improvements to property. It's not, there is something like that in brokerage law, which is if you have not complied with the statute of frauds and you're a broker and you're trying to get compensation and you don't have a listing agreement or buyer up agreement, there's basically no exceptions to that rule. In that sense, it's very similar to what's going on here with contractors, our would-be contractors who are installing goods into property. So interesting case, a lot of money. I think they were talking about how big this removable piece of equipment was. Something like it could be up to 50 tons or something like that. So this is not a dishwasher, right? That you put it on a little dolly and roll in and connect a water hose to. This is a huge item, and anyone who's interested in finding out if you've got a question as to whether someone
Yeah.
should or should not have been licensed, some interesting facts here that would make you think twice.
Yeah, a real
Hey,
trouble
Joel, I
issue of
see you
fact.
smiling. Did you want to, throw in a comment here?
It's just all, you know what? It doesn't matter where you are, it's the same stuff. It really is.
Okay.
Absolutely.
All right. Good enough. We're going to kind of breeze through this next case, which is the County of San Bernardino versus the Insurance Company of Pennsylvania. And it's kind of an interesting set of facts here involving airport property and contamination. And the contamination went way back to World War II when the government was using that property and dismantling planes and disposing of melted down material onto the property. And then during the Vietnam War, this airport property was being used to manufacture some really scary stuff, like napalm, and there was contamination at that point. Eventually, what happened here is that the California Water Quality Board said, "Guess what? There's seepage of industrial waste that's threatening drinking water, and this needs to be taken care of." The county, had to spend a lot of money to take care of it, and the county, of course, had insurance policies that dated back to the relevant periods of time, and pursued the insurance company, and there was three umbrella policies. And so the legal issue here really has nothing to do with the facts. The legal issue is, what does the umbrella policy cover? Was it limited to certain types of coverage, or did the umbrella policy cover all of the incidents that were covered under the policy? Okay, so there's personal injury, there was property damage, and there was advertising, and I don't totally know an insurance policy how that really affects things. But it made a big difference in terms of the total exposure of the insurance company. And as it turns out, there was a California case cited there in the analysis section. You can see it. It's the Garamendi case, which maybe provided some clarity as to what an ambiguous term was going back decades, right? And providing some definition. And the court said, well, once an appellate court reaches a conclusion as to what this term means, if that same term or that same type of policy is used going forward, we now know what that means for any prospective insurance that's issued. But here, these policies dated back to the 1940s. So they say, we cannot look at a decision in 2005 to determine what the parties meant when they signed this insurance contract way back. In this case, we're talking about the 1960s through the mid 1970s. So they said, yeah, that definition, that court interpretation is good from 2005 forward, but we're not going to retroactively tell the parties what they meant when they signed their contract decades before. And so the court wound up saying, how do we decide an insurance policy dispute? Well, if there's an ambiguity, you favor the insured over the insurer. And so this is just a good case that, as I say, not necessarily dealing with airports and industrial waste, but dealing with how do you address terms in an insurance policy, and what do you look at when a case has presumably already addressed that term. Michael, do you got some 2 cents you want to throw in here?
I give you 1.5 cents. So this is what I
Okay.
think. I'm kind of curious how Canada is, because even though I'm a lawyer in Canada, I really know nothing. Um, so I worked for an insurance coverage firm long, long time ago. And I know that when you have to start interpreting these older policies, they were crazy ambiguous. They were not written well. Like, I think people were writing legalese and confused themselves. So this court, looking at the same issue, I like how they concluded they're persuaded that the policies are generally ambiguous. Okay. And just like you said, if it's ambiguous, public policy again has to favor the insured and find coverage. Okay. And this is, like you said, factually, it's interesting about napalm and everything, but it's pure insurance coverage interpretation. If it's not clear, find coverage. Is that how it works in Canada, Joel?
Yeah, we generally don't have decisions of this magnitude at all. Having said that, it seems to me in this case that the judge or judges really wanted to go out of their way to find coverage. So I think it's always the same. I think they'll find in favor. We have a essentially the contract should be governed against the person who drafted it. But in this case, I can see why they uh, would have absolutely awarded the full amount given the time and place. I don't think we have insurance policies that are that old. The way our insurance policies work, it would be very unlikely that you'd have a policy that dated back that far.
And you have title insurance policies, right? And how are there cases about ambiguity with title insurance policies?
Not so far. The title insurers have been, our title insurance experience is relatively short. So we started title insurance about 25 years ago. And the title insurers have really not wanted to be before the courts because the problem is if they start denying coverage, then lawyers are not going to use it. Because in Ontario, prior to the year roughly 2000, we gave lawyers opinions on title that were not backstopped by title insurance. So title insurance really has mostly tried to pay out where they could, and have there's only a few reported cases where they really haven't. There's a Chicago title case here on um, coverage for basements and work orders, and that sort of changed how people do things since that case. But other than that, um, other than that, we don't have any enormous title insurance battles here. The biggest payouts have been for fraud.
Okay. So, Neil, maybe this is a good time for our interview with Joel.
It is, but
Wait a
just
sec,
before you do that,
yeah, go ahead.
two quick things, Joel, and we're gonna get to.
Yep,
Um, One is we have a Q&A tab
yep,
and we have a chat tab. So the chat tab is going to be for
I see that.
announcements that we are making to the audience. The
Yep,
Q&A tab will be for anyone who has a question that they want to raise to any of us. There is a question here, will the program materials be distributed after the seminar? The answer is yes, they will come with your MCLE certificate. You will get a PDF copy of today's PowerPoint presentation. And Joel, we've got the same general rule of thumb in California that you indicated in Canada, which is the general rule that if there is an ambiguity in a contract, it is interpreted against the party who created the
yep,
ambiguity.
you
Of
got it.
course, with insurance contracts, it's always the insurer who
Yeah,
has created that contract, which is why you have that general principle that you favor ambiguities in favor of the insured rather than the insurer.
correct.
So let's stop there with our cases
Uh,
and pick up right where you left off, Joel and Michael, with
Hey,
our interview.
I'm going to jump in right away because I got to tell you something about AI and the Law Society of Ontario. It's quite a funny thing. So, the Law Society of Ontario governs lawyers. It's the Law Society of Ontario is created by an act of our provincial parliament, and lawyers are provincially governed. So I can't practice in British Columbia. I can't practice in Manitoba or Prince Edward Island. I'm really stuck in Ontario unless I want to go get requalified. So we're governed by this body. So this guy does a bunch of bad things and he gets an interlocutory suspension. So the Law Society says, look, until you go to the tribunal, um, you're 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 out. You can't practice. He brings a motion before the courts and says, look, I want to get rid of that interlocutory suspension, except the court finds that his the tribunal noted that the applicant filed motion materials produced with the assistance of AI and that AI was hallucinating, creating all kinds of cases. So he presents this chart to the courts and it's just full of nonsense. So and it later on he says, "Look, I'm really sorry. I can't use. I couldn't afford to hire a lawyer, so I did all this using Grok, and I thought it would be fine, but never checking the references. So his motion, of course, was denied, and the court said, "Look, when it comes time for costs, we may smack you on the hand." So be careful with your AI usage because um, the Law Society of Ontario won't be happy with you if you go before it using hallucinated cases.
And
So
and
that's
Joel, there have been at least two and maybe a third appellate case decided just this year on AI that have basically come down the same way. They've come down, California appellate courts have come down very hard on lawyers who do not bother to check their AI created material.
and a young lawyer here in Ontario was held in contempt of court by Justice Myers for the same thing. So we're starting to see this, real examination of materials that are filed, and I bet you the courts will shortly pass, a directive that makes lawyers sign off that say if they've used AI, they've checked the references and done this and that because it's absolutely ridiculous. And I give expert reports on behalf of our lawyer insurance company, and when people sue lawyers, and I've appeared as an expert before the Law Society Tribunal, and I can tell you my experience with AIs to do research is just terrible. It absolutely hallucinates cases. I did some research on one very narrow area, and the three cases that it came up with are all non-existent. So. It's still not there, which is good for me as an expert because I can't be replaced yet.
Well, Joel, have you ever been involved before with any cross-border real estate matters with Americans or American
Uh,
lawyers?
s- the answer is yes. I used to do a lot of work for a significant used car company, um, and they were purchased by a company in the States called ADESA, which is a very large used car company out of Minnesota. And so we did a cross-border deal when they acquired our assets, and I've dealt with lots of things in the States because inevitably when a lot of Canadians own property in various states, and in Ontario lots of people own property in Florida as an example, and so the cross-border aspects come up, and there's a lawyer in Ontario who's developed this sort of niche practice in, how to hold title to properties in Florida and make sure that it will work out with your estate planning. And so there's all kinds of references. Now I'm a solo and small, so I don't get involved in those mega transactions, but the lawyers at the big firms all have cross-border ties with associations of lawyers that are worldwide. And so they get involved in all kinds of fun stuff, you know?
Well, tell us a little bit about what your practice is. You're a real estate
Sure.
transaction attorney, a
Yeah.
conveyancer.
Yeah. So we don't call ourselves our attorneys. We call ourselves, so we derive most of what we have in real estate from the great country of England, of course. The common law, our mother country, so to speak. And so in England, they have two types of people. They have barristers and solicitors. So a barrister is someone who goes to court. And in England, you can only do one of two things. You can either go to court or you can sit on your butt and do paperwork like I do, solicitor's work. And in Ontario, we have this act called the Judicature Act, and it fused what used to be separated. So it fused barristers and solicitors. That's why we call ourselves that. We do not use the word attorney here. When you use the word attorney, it refers to power of attorney, so that you would have an attorney or governance over someone's either their personal care or their property. So we are barristers and solicitor. I'm a solicitor. I haven't gone to court in years. I go to court in my expert work, but I do transactional work. I do residential properties, commercial properties, leasing. I affectionately refer to myself as a dirt lawyer. So anything to do with dirt, essentially, I do. And then as I got older and grayer, I started to do expert work. So I give expert opinions on the standard of care of real estate lawyers. So somebody will call me and say, "We think this lawyer messed up. What is the standard of care of the reasonably competent real estate solicitor in Ontario?" And then I give an opinion as an expert, and I have to remain unbiased in giving my opinion. And then I have been cross-examined in that. I also do work for the Law Society on really weird real estate frauds. And so when they get a weird fraud, they call me and say, "Look, can you give a expert opinion?" Right now, I'm working on a matter where there's about 19 or 20 lawyers involved in this that were got involved in the same fraudulent scheme. Um, and it's all about elder abuse. The Advocacy Center for the Elderly was involved. And I did work for the Law Society in getting a particular lawyer disbarred. She's now appealed, and this case will go on. But I'm back in at the Law Society Tribunal in September giving expert evidence on these weird frauds, and I will be cross-examined. So that's some of the work that I do, and that's fun. I really enjoy doing the expert work, um, and it's become a nice part of my practice where I get to challenge my brain as opposed to the transactional stuff. So I have a number of clerks who work on that, and we have a really good, robust system here in Ontario, and I know Michael's produced a chart of sort of comparable, how we might compare the two jurisdictions. About 25 years ago, and around 1999, 2000, we had enormous document conversion. So back when I was a baby lawyer in the 90s, if you wanted to close a real estate transaction, you had to go physically to the registry office to do it. You would produce signed wet ink signature papers to a clerk. They would stamp your deed, and that was your ownership. We had a relatively archaic system of 40-year searching, and the government decided in a joint venture with a private company called TerraView that they would create this gateway for searching and registration. And it, of course, revolutionized things because now a lawyer in Toronto could close a real estate transaction anywhere and wouldn't have to physically go to the registry office to complete the transactions. And when we went to the registry office, the buyer and the vendor would meet at the registry office, exchange money physically for keys. Our clients would come to the registry office to pick up their keys. It was archaic. You had to do 40-year searches. So there was a case in Ontario at the Court of Appeal level that said you have to go 40 years back from the date of the agreement of purchase and sale and search title. And there was none at all guarantee of title given by the government. When we
So
switched,
Joel,
yeah,
this is kind of interesting. So that's why I
yeah,
made a chart that, and we'll provide the chart to everybody that's, watching this. But
yeah,
there are some fundamental differences between, fraudulent deeds in California versus Ontario. And you mentioned 40
sure.
years. So if there's, for example, a forged deed from 45 years ago in California, if you have that, title thereafter is bad, right? So you're saying in Canada that's not true?
So we have a doctrine of deferred indefeasibility here. So once you get one away, you're done. But if you catch it at the first instance, you can apply to the Land Titles Assurance Fund. But mostly, title insurance will defend your title, or if a fraudulent mortgage is registered. We have very little fraud in the system. So the incidences of title fraud and fraudulent mortgages registration are very small but large in value, and that's the value of title insurance, and that's why most lenders will insist on it, and we recommend it to all our purchasers for that very reason, because it's cheap. A a a purchaser buying $1 million property pays $800 or $850 for a title insurance policy, which lasts their entire lifetime and as long as the estate owns the property. So it's a one time, and there's no deductible, and it's a claims made policy. So as soon as you make a claim, it'll go through the claim system and be adjudicated.
So
Uh,
the process in Canada, I was really curious when you said about running to the county, the courthouse, whatever, to
yeah.
send you money. So today,
Mm-mm.
here in California, we use escrow companies and title companies. So in Canada, who's the one transferring the money back and forth?
The lawyers. So on we use an escrow agreement, which the Law Society actually drafted. It's called a document registration agreement, and it is an escrow agreement agreed to between buyer's lawyer and seller's lawyer. So our buyer clients give us their money. We act in a joint retainer with the financial institution. The financial institution advances money to us, to our trust account. And then we typically wire transfer funds to the seller's lawyer. They release a deed electronically through the gateway. And then we register the transfer and the mortgage, and the seller's lawyer releases the funds. and will pay out mortgages, liens, tax arrears by way of undertakings.
So your
Uh,
your bank account must have millions of dollars in it.
I think right now I have about 12 million in there. And that's only because we closed a farm deal that was 7 million yesterday. So we've been paying out mortgages and giving the balance to the client. So we deal with millions and millions of dollars all the time. There was recently a case where lawyers have used their trust accounts as Ponzi, in Ponzi schemes where they use other people's money to pay out other people's mortgages and have dipped into it. The incidences of are fairly small. The Law Society audits our trust account every few years. And essentially, it doesn't happen very often, but um, our trust accounts are relatively significant at any given point in time, although the money doesn't stay for long because it goes in and out. The only time in divorce cases where people sell their homes, sometimes they haven't agreed how the net sale proceeds will be divided. So in those cases, we hold them, we buy interest-bearing GICs with that money, and then we'll either get a court order or a mutual direction to release.
Mhm. So as a solicitor, are you also involved with giving opinions about if there's a defect, like some, that, oh, they didn't disclose something, or there's some defect, or, you know, these types of legal issues, or are you just processing paperwork and bank account
No,
money?
no. So we deal with so I just dealt with on the farm deal, there was some questions about the legality of one of the conveyances. So I had to do a historical title search to find this root document, which I did find. And then we use some of our curative provisions to fix it. So we're fixing problems all the time, and we do get involved, of course, in disputes. Once, if in fact a buyer decides they're not going to close or a seller for whatever reason, we would hand it off to litigation lawyers at that point. But we do all the setup work. So we would, if one side or the other didn't close, we have a process called tender. And tender is an evidentiary process where we show, and these words have meaning in Ontario, that a buyer or a seller was ready, willing, and able to complete a transaction. And it's an evidentiary process. Once that's complete, we usually hand it over to the litigation lawyers, and they start suing each other, a buyer or a seller, in a dispute. But we're involved in,
Joel, are
yeah,
solicitors involved in like renegotiating the deal? Let's say there's a defect, people want to credit. Are you
sure, of
involved
course.
in that aspect?
Absolutely. So, some an agreement will be signed, and then they say, "Oh, we discovered on our last walkthrough that this happened or this happened. We want abatement of the purchase price in X amount of dollars," and then we go at it.
Mhm. So are you more taking over the case from the real estate brokers once, the terms have been agreed to?
Absolutely.
Or
There's standard forms of agreements of purchase and sale. Real estate agents and brokers use this Ontario Real Estate Association template. We have access to the template. I'm licensed to use the template as well, and they draft agreements of purchase and sale. And once the deposit is paid, that agreement is binding in accordance with its terms. And then they handed off to us, the lawyers, and then after signature to closing, we search title, we liaise the buyer, seller, and uh, buyer's lawyer and seller's lawyer liaise. And the buyer searches title and produces any objections that they might have to title. Documents are prepared. We prepare the documents associated with the mortgage, and we bring in the client to get everything signed off. We do things virtually since COVID. But prior to COVID, we were not allowed to sign up virtually. Clients came into the office to sign wet ink. Since COVID, the Law Society sort of opened Pandora's box, and we do everything virtually now by Zoom and DocuSign.
so once
So
Um,
you get the case,
yeah,
uh,
Joel, I'm gonna have to terminate this interview.
yeah,
We've got some other cases we want to get to.
let's
We might
go.
have some time at the end to pick
Let's
up
go.
some more information about you, Joel.
Yeah.
So Before we move on, though, I do want to tell everybody that in the chat tab, you will see that Morgan, who is the assistant here at CLA, she has posted two documents. Michael has created two documents. One, or he didn't create them, but has provided for us two documents. One is a comparison between Ontario real estate law and California real estate law, and the other is, I think it's also a comparison about different ways of holding title, distinguishing
Yeah.
from what is done here and what is done. So you would have to click on those, open them up, and then save them if you are interested in either of those two documents. And I see we do have a question from somebody named Anonymous Attendee and is curious about the pros and cons of transfer on death deeds. And I don't purport to be expert enough. I believe a lot of that is done to avoid probate if you have, particularly if you have just like a single property or if you do not have multiple properties. But it's really a question for a estate planning attorney, quite honestly, to go into what are the pros and cons of transfer on death deeds versus having a probate versus distributing by will, for example. So unless Michael has some special knowledge about transfer on death deeds, then I think I'll move on to our next case.
Well, all I can tell you is they're defeasible. So if you did a transfer on death deed and then the person changes their mind, they can cut you out of receiving the property at any point in time while they're alive.
Okay, so for the intended recipient, don't don't rely, don't rely,
Oh,
don't.
one more thing. I remember that these are called ladybird deeds. I don't know why. There's something about, I guess, a case someplace, Mrs. Ladybird.
Okay, well, good to know. Thank you, Michael. Thank you, Joel. Please stick around for the next
I'm sticking around.
18 minutes, right? And again, as we're going on, if you want to opine, please do so. And let's move on. Pung versus Isabella County, Michigan. So, an interesting case here went all the way up to the United States Supreme Court, excuse me. And we've got you know, what's your basic facts? The basic facts here is the county held a tax sale and the amount that was owed. So here the homeowner owed a whopping $2,241.93. The county foreclosed on the property and sold the home at a tax sale for just over $76,000. Before the tax sale, the property was assessed at $194,000. So the tax sale yielded, assuming that the assessed value was the fair market value, which is not always the case, but let's just make that assumption, yielded about 45% of the assessed value. Now, kind of an interesting backstory here that we'll get into when we talk about the concurrences and the dissent is that initially the county kept all of the money, right? They didn't just keep their $2,241.93. They kept all $76,000. Nice county that we have going on here. Um, the county said, listen, we complied with the law. We gave notice to Pung to redeem. Pung did not redeem. There was a public notice of the sale. Uh, they sold the property to the highest bidder. You have to obtain a judgment in Michigan court in order for this to be finalized. So there was plenty of opportunities, right? Pung, you could have sold your property, you could have refinanced, you could have borrowed $2,241.93 from a friend and paid us off, but none of that happened. And after the sale, Pung challenged the sale, and what led to this particular case going up to the U.S. Supreme Court was the challenge was based on two items of the U.S. Constitution, that it was an unlawful taking, that Punk says we were not given fair value for our property. So property was taken from us. And because our property was taken, and not just $2,241 worth, $2,242 worth, but what Pung is saying, $194,000 worth, that's an excessive fine, for the amount that we owed, which is just over $2,000. At federal district court, the court said, Pung, you are entitled to the difference between what the county collected and the amount that you owed, right? So approximately $74,000. I read this. I'm just amazed that the county kept the entire money initially. So the district court said, yes, you're entitled to that, but you're not entitled to the difference between what the tax sale yielded and what you are claiming is the fair market value. The Sixth Circuit affirmed that decision. Pung brought presumably a petition of writ of cert to the U.S. Supreme Court. And I wrote down there California Supreme Court. That's wrong. It was U.S. Supreme Court. I apologize for that mistake. And the U.S. Supreme Court affirmed, said, you know what, if we have to go based on somebody's claim for fair market value, basically we would have just destroyed the ability to have tax sales in the United States. And these have been essentially a time-honored process in the United States, going back to the Magna Carta. I love when cases, just cite, arcane law and said, uh, it would be impossible. What would happen here? Counties would be negative, would be net negative if they had to supply, in this case, the difference of, almost $100,000, or actually more than $100,000, because the claim was that the tax sale did not yield fair market value. I said that's just not a practical thing to do. It's inconsistent with the history of tax sales in the United States. And basically they said, yeah, to say that there's an excessive fine, if we did that, we would be holding the same result, which is we would basically be eliminating the possibility of having tax sales for people who are behind. Now, Michael, I'm going to let you talk a little bit about this, and then when you're through, if you haven't covered it, I'm going to talk about the Justice Thomas dissent.
Well, look, I agree. These people got screwed, okay? But I can see the practicality of what has to be involved in conducting a tax sale and the valuation, all that sort of stuff. But as you said, not this opinion does go back in time a little bit. And I like the short discussion of some Blackstone law. You can finish it up with what Judge Thomas had to say about Blackstone.
Well, what I really wanted to talk about more about what Justice Thomas had to say about the facts of this case.
Oh,
Because you look at this and I look at this and like I don't understand how could Pung not come up with $2,200, right, and then risk losing the family property, which was the family property for over 20 years. How could that have possibly happened? And the majority opinion doesn't discuss any of that. Just he owed the money, didn't pay. There was a tax sale. The tax sale was properly conducted.
yeah, there's no background. Where's the background here?
Right. None. So Justice Thomas provided the background, and Justice Thomas said there was a ongoing dispute between Pung and the county as to whether the homeowner's exemption applied to this property. There was lawsuits. Pung won, I believe, both of those lawsuits. And then, as Justice Thomas said, the county assessor basically said, the hell with the opinions. I'm going to assess this extra $2,200 based on the fact that I don't believe, despite two court opinions, I don't believe that this was Pung's family home. And so the homeowner's exemption did not apply, right? And so as a result of that, the assessor made the assessment, went through the process. Pung says, I never got notice. I never got notice. And so I never had an opportunity to cure. I never have an opportunity to remedy. Remember, the majority opinion said, you have notice, you had an opportunity, you had time to remedy, you didn't do any of that. Too bad for you. You made some bad, stupid decisions. But when you read the Thomas dissent, Thomas also had a concurring opinion, or was one of two justices that had a concurring opinion. But when you read this, you're like, oh my God, this is grossly unfair. Now, what the Supreme Court said is we are not judging whether the conduct of the sale was fair. That's going to have to be dealt with by the lower courts on remand. And if I look at the Thomas opinion, I say, I think Pung has a chance to say the process was unfair if they never received notice, if they never received notice of their right to redeem. And I don't know. Somebody's been spending a lot of money on this case, but to me, I think there is at least a 50-50 shot with Pung that a lower court may look at the actual facts as opposed to looking at the process and saying factually there was an unfair process in this case.
How
Good
how
chance
on
there. Do I know? I don't.
how on earth does this land at the Supreme Court though? Like, is there a
So
test? Is there a test to get before the Supreme Court? Because a case here at the Supreme Court has to be of national importance to get to the Supreme Court of Canada.
yeah. So I believe the U.S. Supreme Court, just like the California Supreme Court, can decide what they want to hear, right? So I think the policy issue in this case, which whether tax sales, and every state has tax sales, really is of national importance. And how do you value? Do you value based on the amount received at the tax sale, or do you value based on some theoretical amount where you could have factual disputes as to what the fair market value is? So I think the Supreme Court addressing that issue, probably a fair issue for the Supreme Court to address. And maybe that's why the majority sort of stays away or ignores the underlying facts in this case, right?
Yeah.
Because they want to deal with the bigger overall conceptual issue rather than the impact on this one particular plaintiff.
And then the
Right.
technical issue, Joel, is to find a federal question, which here they said was the Fifth Amendment about a taking or the Eighth Amendment about unfair fine or penalty. So they once they have the legal issue that's in the jurisdiction of the federal court, then that kind of like gives them the technicality to rule on it. And when it's involving the state, it's involving the government.
Michael, I don't know. Do you want to talk about this last case? I don't have a full analysis, but I just kind of gave some key issues here. And I know this case interested you. Do you want to talk
I'll
about
go.
this?
I'll go real quickly because then I
Okay.
have like a final question for Joel. But
Okay.
we have this case. It was an interesting one. It was about disqualification of a law firm. Okay, and this is Munger, which is a giant law firm, versus Dan Drake. And this case, it was in, I guess, Bakersfield, Kern County area. It's kind of a rural area, but it's like the largest. It's the big oil producing area. But what I liked about this case is the Court of Appeal was looking at what involves when an attorney, an associate attorney who worked on a case, transfers to the opposing attorney's law office
Mhm.
and is working there. The bottom line here is the associate that transferred law firms, when she was interviewed, she didn't disclose that she worked on a case where the opposing lawyer was at the place where she was interviewing. Well, that cost her her job. She lasted like 10 days, then she got fired. And then these law firms, big law firms, they started battling each other. So all I want to say is like the takeaway is if you're going to be, if you're working in a law firm and you're working on a case that's also involving the law firm where you're going to hopefully move to, you better tell them that you're involved in that case. But the legal issue here is that the Court of Appeal was focusing on the rules of professional conduct, and they've been modified over the last several years. And they're looking more like factually was there, we used to call it a Chinese wall, which maybe is not appropriate, but some sort of ethical wall to isolate the attorney. And the court said that, look, the second law firm, once they learn about this person that has maybe an actual conflict, they tried everything possible to isolate her, and eventually they fired her. And there is also one evidentiary thing I just want to mention because I like the practicality of law. People saying that there's a self-serving declaration by the second law firm about the steps they took to provide an ethical law. And the first law firm was saying, oh, this is a self-serving declaration of his partner, don't care. But here's why the court didn't buy that argument. That self-serving declaration was full of facts. And when you're doing a declaration in court, you can't have conclusions. It's just like pleading requirements. Have the actual facts there, what you did to isolate this attorney. And they talked about terminating and isolating her phone communications and access to files and physically where she was. That's all I'm saying. So that's that case.
Yeah, it was a fascinating case. Michael, I know you got one more question for our guest, but before we get to that question, drum roll, please. Today's MCLE winner for 1 hour of online MCLE is, yes, thank you, Joel, is James Straw. I think it says Straw, James Straw. So, James, when you get your certificate for 1 hour of self-study, like all of you will get who listen to today's program, James, you will also get a gift certificate, and hopefully you will make good use of that in the RPLS section of the CLA online library. Michael, you have something else that you want to ask
It's,
Joel about? I'm
well,
just going to show our last screen while you're asking the question.
well, here's the most important part about being a lawyer. So, Joel, what is the best part of your life?
Oh, my whole life.
Your whole life. What's the best part?
I,
Why
I
do you
think the
exist?
I think you know what? One of the most important things I've done in my life is I am the father of a trans man. And when my son came out, I reached out for support. We have in Toronto and in Canada, we have a PFLAG organization, and it's right across North America. PFLAG is. It used to stand for Parents and Friends of Lesbians and Gays. Of course, now it's just parents of kids on the flag. And it's a parent support group, only peer to peer. And I started when I started going, the dads struggled with uh, talking about gender and sexuality quite a bit. And so I started a dad's night through Toronto PFLAG, and we meet once a month in a bar, and we talk. We give peer-to-peer support for dads of queer kids. And to be honest, it is one of the greatest accomplishments of my life. We started over 10 years ago. We got 200 men on our mailing list. We get about 20, 25 guys out a month. We have 4 facilitators. I'm the lead facilitator. And I think it's one of my greatest accomplishments just because we change people's lives one family at a time. We're not trying to change the world, but we give peer-to-peer support to parents who are interested. We get referrals from hospitals, from Children's Aid, from all over the place, and I'm really, really proud of having established that and having that up and run. And so that's probably one of the greatest accomplishments. I have 3 kids. They're terrific human beings, and of course, they're my greatest accomplishment. So thank you for asking that.
All right. Thank you, Joel.
Hey, Joel, we've got 1 minute here. I want to ask you a question about what you just said.
Yeah.
You said you meet in a bar. Do you meet like in a back room? I mean, how are you having these conversations?
So
I
the
perceive a noisy bar, so I'm
yeah,
wondering how you
of
do
course.
that.
The bar is in our queer village, and the bar was kind enough to give us their entire second floor every one Thursday night a month, and we have our own wait staff, and they give us those 2 or 3 hours to ourselves, and we buy food. It's not like a minimum spender. They're just incredibly kind to us. Um, and so we meet down there and we gather around a table and we have a cup of tea or a beer and we talk about how we can support our queer kids. And we've had tremendous support from this one bar, and we love them, and they've given us a home.
Well, thank you so much for joining us today. We're right at 1 o'clock. I'm going to say my quick goodbye. I hope we see the attendees. I hope we see you next month, Thursday, August 20th, same time, 12 o'clock, and we'll have a bunch of new cases to talk to you about and maybe another interesting interviewee. Michael.
Well, thank you for joining us. If anyone has a desire to be interviewed or wants us to explore a topic, let us know. But if not, Neil is gonna find you the most interesting updated questions, including dissenting opinions that exist.
Fantastic stuff.
Bye, everybody.
All
Thank
right.
you.
Bye. God
Thank
bless. Take care.
thank you. Bye.